Hello, my name is Samiksha Jadhav and I work as a Senior Associate at Risk Pro India. Today, we are going to explain a bit about the Data Protection Board of India. Now, the Data Protection Board of India is an adjudicatory body, which means the body has the power to act as a judge in a conflict or to make a formal decision in a dispute. As per Section 2C of the DPDP Act, the Data Protection Board of India is to be established by the central government under Section 18 of the Act. It is a body which will be responsible for adjudicating matters of personal data breach and violations of the DPDP Act. The board will be an independent body corporate having perpetual succession and common seal. Now, some important aspects relating to the board are the composition of the board. A question arises as to whom shall the board consist of. The Data Protection Board will consist of a chairperson along with certain number of members as may be notified by the central government. The chairperson and the members of the board will be appointed by the central government and they will be considered as public servants. They shall hold the office for a period of 2 years. Now, who are qualified to be a board member? The chairperson and the members shall be persons with ability, integrity and standing, who possess special knowledge and practice experience in certain fields, and at least one of the members shall be an expert in the field of law. It is important to note that a person will be disqualified as a chairperson or a member of the board if the person has been adjudged insolvent, is convicted for an offence involving moral turpitude, is physically or mentally incapable of acting as a member, has acquired financial or other interests which are likely to prejudice the functions as member of the board, and has abused the position to continue office. Now, with regards to the powers, functions and proceedings of the board, as far as practicable, the board is required to operate digitally. Their functions such as receiving complaints, allocation, hearing, pronouncing orders, etc. shall be carried out digitally. The board has a power to inquire into the matter upon receiving an intimation of data breach or upon complaint from the data principal with respect to any breach or the breach of data fiduciary's obligations with respect to the data principal's rights. The board can also initiate inquiry upon reference of a matter through central government. If the board believes it has sufficient grounds to proceed with an inquiry, it has powers to inquire in the affairs of any person to determine whether they are compliant with DPDPA or not. As per Section 28 Clause 7 of the DPDP Act, the board shall be vested with the same powers as of a civil court. This shall extend to the matters of summoning, examining, receiving and inspecting evidences. However, the board cannot prevent access to any premises or take any equipment from the custody which can adversely affect the day-to-day functioning of that person. In case of data breaches, the board may direct any urgent or remedial mitigation measures in addition to inquiring and imposing penalties. If the board is of the opinion at any point of time after receiving a complaint that the complaint is false or frivolous, it may issue a warning or impose a penalty on the complainant. The introduction of a separate body to govern the violations of DPDP Act will help in effective application and remediation of the violations. Let us wait for additional government guidelines to be more specific and clearer towards the concept. Thank you.